Well, it's a great pleasure to participate in this 10th seminar. I'm Luis Fernando Martins Castro. I'm a board member from CGI. I am a lawyer. My background is a lawyer. And I was appointed to CGI since the previous administration. Sorry. We still need to invite Alexandre Pacheco from FGV. Sorry, Alessandro. Be mostly welcomed. You attended the previous panel, and you should have noticed that everything will be super easy, fast, easy, and with no questions. I attended Laia's presentation, who will define if the data is open, if it violates a privacy right. I remember that when the Information Access Law was approved, there was a very rumorous case. The municipality of the city decided to present on the transparency portal the salary of all employees, and this caused some discomfort. This matter was discussed and went to the Supreme Court, and the Supreme Court decided that among the rights to privacy and transparency of information, the public interest would prevail. So we know that all the rights should be analyzed and considered in a broader context. And in the few examples that were presented in the previous panel, how many examples we have that raise doubts about the application of the law. So we ask who will help or who will solve these questions. These questions can be solved by whom decides, maybe the market, and the many sectors will talk among each other. They will reach a consensus, and they present a solution. We can have a case like this, like the payroll of Folha de São Paulo newspaper, where the Supreme Court was invited to decide what should be made. And our national authority will decide everything. And we had a delegation from CGIs. We were represented by the 4 sectors. Paragem, myself, Flavia, representing the 3rd sector, and José Luis Ribeiro representing education. We went to Brasilia. We talked with the Science Technology Ministry, the presidency, and we were really at ease because they said, as we have very few funds, we'll try to find 20 idle servants, public servants, and we'll start the agency. So many things will happen, and we at CGI said that whatever we can help in terms of our experience and our knowledge, we'll do. But we know everything has its own right and difficulties. To discuss this, on an approach to implement the data protection law in Brazil, we want to share this with the foreign experience. I suggested that we listen to representatives of foreign agencies. We have the lawyer from CNIL and a Mexican lawyer and a Chilean lawyer presenting their experiences. And we need to listen and understand what others did, what are the obstacles. I recently participated on Eurodic, and there was a panel that called my attention, called the blind spot of GDPR. we had more blind spots than clear spots. So I will hand it over to Hori. Hori, be mostly welcome. We want to hear your experience as member of the ICO in the UK. He was an important player to deploy GDPR by the English agency. So we asked him to talk about his experience, the relevant points, and if he faced any problem or any obstacle to implement his work, to tell us. Be mostly welcome. We hand it over to you. Just for we propose him to talk for 20 minutes. Each one of the panelists will talk up to 20 minutes. He said he's not a talk guy. So for the other ones, they have 10 minutes to do a brief presentation of their point of view and their comments, and then we'll open for the floor. We'll open the floor. Be mostly welcome.
Thank you very much for that kind introduction, and thank you all for staying here and not being out there drinking, which is what I'm sure everyone would prefer to be doing. And also, I'd just like to thank the organisers for what I think has been a really excellent and valuable day so far, and looking forward to this evening's debate and to tomorrow. So I'll introduce myself. My name is Rory Munro, and I'm the Head of International Engagement at the Information Commissioner's Office in England. We're based in Wilmslow, which is just south of Manchester. It's where all the footballers live, if you're interested. But I'm based in the London office, which is also very central, right next to Trafalgar Square. I've only been there since January, and before that, I was a career civil servant working in the Ministry of Justice and its various predecessor bodies. And since 2014, I've been working on data protection. I was the head of the UK's delegation to the European Union Data Protection and Information Exchange Working Group, which is what negotiated the GDPR. And I was also the head of delegation to the Council of Europe, where we debated the modernisation of Convention 108. So I probably won't speak for 20 minutes. But I'll just give you a bit of, I think what I'm going to try to do is talk in three broad parts. So I'll talk about, I suppose, my former life, which was GDPR negotiations, which also inevitably leads into a bit about Brexit, because the last 3 years have been all about how is the UK going to cope with data protection exchange with the EU and also the rest of the world when we become a third country following our exit from the European Union. I think it's still on the cards, although the court case today is, there's a big court case in the UK which may make quite a difference to what ends up happening. And I think there's a judgment on that either tomorrow or Friday. Anyway, then after that I will go on to a bit about the ICO's work in terms of regulatory cooperation and enforcement, investigations. And thirdly, just touch a little bit on what the ICO is currently doing to try to keep, if not one step ahead of, then certainly abreast of innovations in the tech industry and the sort of thing that we're doing to try to make sure that we're on top of everything. So, excuse me, a brief history of European data protection legislation. Well, the Council of Europe set up its Convention 108 in, I'm going to get the dates wrong, but something like about 1985. And the Information Commissioner's Office was set up in 1984. We had a staff of 10 then, and we were called the Data Protection Registrar. And as a result of the Council of Europe's Convention 108, which sets a set of principles and broadly high standards, for Council of Europe members. The European Commission then moved to introduce a Data Protection Directive of 1995, and that became the UK's first Data Protection Act, or first act covering overarching data protection issues in 1998. And then there have been various modernisations, and of course there was the Commission's production of the regulation, the GDPR, in 2012. And as I say, I became the UK's lead negotiator on that in 2014. So it's difficult for me to talk about implementation issues in terms of the initiation of data protection in the UK, because that happened when I wasn't working on it. But in terms of the negotiations, and you'll have to forgive me, an awful lot of the difficulties that the UK experienced in negotiations at the European Union were political rather than specific to data protection. So at the time that we were doing the negotiations, the Secretary of State for Justice was a man named Chris Grayling, who is a very vocal and passionate Brexiter, and even at that time was agitating for the UK to leave the EU before the referendum, and consequently was not hugely interested in the UK negotiating a European regulation. So the initial obstacle was a political one that we weren't really sort of in the room. But we eventually got to, and when I say that, I don't mean we empty-chaired the meeting. I mean we just spent our entire time saying this shouldn't be a regulation, it should be a directive. And the difference being a regulation is directly implementable, and a directive leaves discretion to member states as to how they want to implement it. Anyway, we then went through the negotiation process, and the GDPR is the GDPR in quite large part because it's a result of 28 different data protection cultures and sensibilities trying to be mashed into one thing, which is why we say that it's either a directivized regulation or a regulated directive. It's not really a true regulation because there's still quite a lot of member state discretion, which is one of the reasons that it's quite confusing, and some of the things that you heard Orla Linsky talking about today are as a result of that. It's a problem that I wouldn't anticipate that you would have with your law because you're negotiating with yourselves rather than with 27 member states, but it's worth bearing in mind. And I know that there are similarities, but so we ended up with the data protection GDPR as it is, and what I'd say the UK's successes primarily would be around getting it to have a more risk-based approach, so that the requirements on controllers and processors are more stringent when the risk of the processing or the data that they control is greater. So if it's high volume or highly sensitive, then the requirements of the controllers are great. So they're more likely to need a data protection impact assessment. They're more likely to need a data protection officer, etc. Originally, the Commission's original plan was set a much lower test, so there was much more heavy regulation on even micro businesses, and so there was a certain amount of, I'd say, it wasn't just the UK, there were other countries also negotiating this, but to try and sort of shift the balance. Overall, and I mean the UK supported the GDPR when it came to a vote. It's by no means perfect, and there are several things that we'd probably change if we could. In my personal view, it's still too prescriptive, and it still places too much of a burden on certain controllers. But given that the fact was, however imperfect, as we heard Orla say earlier, the idea of giving back control to data subjects, however imperfectly it's done, that was the central principle really behind it. That the feeling was that big data processing businesses had got too much power over individual citizens' data, and they didn't have enough agency over it, they didn't have enough transparency over what was being done, and they didn't have enough say in what was in how that data was used and onwardly transferred. So the principle was to give data subjects greater control. As other speakers have said, that's not necessarily enough, and it's not necessarily done it's by no means done perfectly in the GDPR, but that was the principle. So it was approved in 2016, and my main interaction with controllers and processors was during the negotiations when we were being lobbied very hard, it won't surprise you to hear, to try and reduce some of the burdens. And something that I suspect that the regulator here and also the legislators here are going to find, although it will be different. In the UK, we already had, as I said, a 1998 Data Protection Act. The GDPR came along, and the most significant thing about it in difference was the size of the fines. So the fines went from a maximum of £500,000 to 4% of global turnover, or 20 million euros, which is, I don't know, it's probably about 17 million pounds now. I don't know what the exchange rate is. But anyway, it was a significant rise. And we were constantly being lobbied by businesses saying, the GDPR is going to kill us, it's going to put us out of business, we're not going to be able to do X, Y, and Z, which is our bread and butter processing now. And we'd say, show us in the GDPR where it says you can't do that. And they'd say, here, here, and here. And we'd say, all three of those are in the Data Protection Act 1998. So are you telling us that you've been processing illegally for the last 18 years? Which sort of focused their minds, and they tended to go away and think about different arguments against the GDPR. But interestingly enough, and I don't know whether you'll find this, the lobbying stopped once it became agreed, because they were just like, okay, this is the law now, we're just going to have to work with it. So that's quite an interesting takeaway, because it was quite brutal, some of the challenges we were getting. You know, you people aren't doing your jobs properly, and no acceptance. And this is not a woe is me, but no acceptance that there were 27 other countries in the room and we weren't always going to get what we wanted. But there you go. So that was the sort of historical bit. Another team in my department, I then moved from the Ministry of Justice because data protection moved to the Department for Digital Culture, Media and Sport, which is now the department that deals with cybersecurity, digital single market, data protection. And that was the point at which we had the Brexit referendum. And since then, up until January when I moved to the ICO, the work was primarily about planning for a negotiation, which never happened on data protection. There's still not been any meaningful negotiation on data protection. Preparing for how we could... So the original plan was that we wanted something more than adequacy. The GDPR says if you're going to transfer data to a third country, that third country has to be deemed by the Commission to be adequate. And our view was, and probably remains in government, that of course we're adequate because we're fully aligned, so therefore we want more because we're also very important to you, and we'd like the Information Commissioner's Office, for example, to still have a role in the European Data Protection Board, which is the body of all the 28 data protection authorities in Europe, and we'd also like some of the other some other restrictions which would normally apply to third countries removed. That was the negotiating tactic. As I say, no negotiations ever took place, and we're now at the basis of, will the UK even get adequacy? And that is quite a big question, which would take longer than the time I have available to talk about, but I'm happy to have a chat with people who are interested. It's a very UK Brexit-focused point. But and those conversations are still ongoing. I know, obviously, from colleagues in UK government, what's happening with current data protection preparations, what are the problems with the way that the UK has implemented the GDPR, because we now have a Data Protection Act 2018, which not only implements the GDPR, it also implements the accompanying law enforcement directive, which went alongside the GDPR but dealt only with law enforcement processing. And it also, for the first time, codifies our data protection processing for national security purposes. That's been in other legislation like the Regulation of Investigatory Powers Act. It hasn't been in data protection legislation, and part of the reason we've done it like that is because of Brexit. So it draws on the very small national security processing bits of Convention 108 and puts them into the Act and tries therefore to sort of, if you like, vacuum pack them so that no one can look at them, because this is an area that, again, it's a long story, but national security, now that we've left, when we leave the EU has competence to look at third countries' national security processing of European citizens' data. It doesn't have competence to look at member states processing, national security processing. So it's an unintended consequence of Brexit that we sort of actually lose a bit of control over some of our most sensitive data. So as I say, those discussions are still ongoing. The whole Brexit debate is still ongoing. There's political turmoil in the UK, so it probably doesn't do very much to focus on that. But that's the history of a broad brush history of what happened in Europe very quick in the last 40 years, and my tiny, tiny part in it. And then I'll move on to something slightly more present now, which is the ICO, and in particular its work on regulatory cooperation, both with other regulators in the UK, which is a little bit, and also the importance of cooperation with other countries. And this has a bit of a North American feel, but it's equally applicable to other countries because we do a lot of exchange with the Federal Trade Commission and the Canadian Data Protection Authorities. We hope that we will also be working closely with the new Brazilian Data Protection Authority, but we're not confined by any means to those. We work with over 50 countries, and we're quite prominent in certain international organisations. So, so with the implementation of the GDPR and our new UK legislation, we've been through a significant growth process, and we've taken up new powers to bring our capability in line with the challenge of regulating personal data use in the digital age. So this reflects the importance that the UK government places on data protection and the seriousness of recent scandals involving the use of personal data in the political process, including the Facebook and Cambridge Analytica case. In granting powers, the UK Parliament has gone further than many other EU legislatures to ensure that the ICO has both the resources via its funding arrangements and powers to do its work. There's significant national debate about these, with checks and balances provided by the dedicated Tribunal of Information Rights judges in the UK who oversee our work. We also, for completeness' sake, have responsibilities beyond our data protection remit, so we're also responsible for freedom of information cases, access to public records and access to environmental information as well, and for oversight of retained data under national security legislation and the security of some critical national infrastructure systems. So we now have, it will shock those of you who are in the business of setting up the Brazilian Data Protection Authority, approaching 800 staff. As I say, in 1984 there were 10. 2 years ago there were 350. We're now nearly up to about 800. And we also have new powers to search premises, seize equipment, examine algorithmic systems in situ, audit company systems or procedures, compel provision of information from wherever and from whomever holds it. Where we find breaches of the law, the Office has the power to issue significant fines, require changes to processing and prosecute offenders through the criminal courts. We deal with around 50,000 citizen complaints and undertake about 3,500 investigations every year. Our remit covers both commercial as well as public and law enforcement sectors. So in many ways we're learning as we go with these new powers and resources. It's quite a significant change from 350 to nearly 800 in 2 years, and there's, let's say, growing pains within the organisation, but it's positive that we're being so well resourced, of course. One of the key learning points has been that of the importance of working collaboratively with others internationally. Many of our most significant files on the ICO investigations team, many of the most significant files the ICO investigations team are considering at the moment involve other jurisdictions and authorities. And in the last 12 months, we have had engagement or exchange with over 50 nations. As our citizens become more aware and concerned about the use of their data, and as companies become increasingly span more than one country, the need to work together becomes more important. Our citizens compare and contrast the rights they enjoy and the response they see from regulators and law enforcement agencies. Our work as a regulatory community is in the public eye like never before, and confidence in new technology depends on it. With this in mind, we value hugely in the UK our positive relationship with colleagues on this side of the Atlantic, but as I say, in the Federal Trade Commission, and also in Canada, and we hope to build bridges with Brazilians, and we also use a lot of different networks involved which involve our international partners, such as the Global Privacy Enforcement Network, the International Data Protection Conference, which Commissioner Elizabeth Denham is the chair of, and that conference is in Albania in October. She's also the chair of the International Conference of Information Commissioners, which is a Freedom of Information Conference, and that's taking place in Brasilia next year. And then there's the Common Thread Network, which is generally with countries which I think we'd say are less data mature, so some African nations, for example. And we learn a huge amount from these mechanisms, and the exchange of tactics, intelligence, and approaches that they allow are invaluable. We have a number of legal gateways to share and receive information from counterparts overseas, which are backed by strict protections in governing law that provide security for the received information and are backed by criminal sanctions. In the course of our investigations, we may use several or all gateways, such as bilateral agreements in memorandums of understanding, mutual legal assistance treaties, membership arrangements, such as membership of the Global Privacy Enforcement Network, or ICD-PPC, or indeed procedures set out in Convention 108. Which will be appropriate at any one time will depend on the nature of the exchange and the receiving or sending authority. On the EU side, we're a competent authority for the one-stop shop mechanism, which is the mechanism by which, prior to the GDPR, if you were a pan-European network, pan-European controller, like, say, Google, and there was a pan-European data breach, you could be fined 28 times and subject to 28 different investigations. The one-stop shop places that power in the lead supervisory authority. In Google's case, it would be Ireland, because their main establishment in Europe is in Dublin. But then all the concerned supervisory authorities can put in their own comments, and if there is any dispute at the end of this process, then the European Data Protection Board resolves it. So it's the dispute resolution mechanism for that. Around a fifth of the cases in one-stop shop involve the UK, either as a lead or concerned authority. And many of the big issues we're grappling with internationally are being explored in these files, such as algorithmic transparency, state use of surveillance, wider use of facial recognition, ad tech, micro-targeting or profiling, and use of children's personal data. And one-stop shop is a comprehensive cooperation mechanism allowing free and secure exchange of evidence, including personal data and certainty for the organisations involved, that they won't have to deal with multiple competing requests. And in addition to those, that cooperation that we rely on and strive to build internationally, is cooperation that we also have with, which I know, I think probably every speaker so far has touched on, internal other regulators. So in the UK, for example, we work with Ofcom, which regulates internet broadband services, as well as harmful and offensive material on TV, radio, and on demand, and things which are delivered online. The Competition Markets Authority, which has an interest in regulation of tech company monopolies, the Electoral Commission, which regulates elections in the UK, the Financial Conduct Authority, which plays a significant role in supporting financial institutions to protect themselves from cyber attacks, and the British Board of Film Censors, which regulates digital age ratings for video content online, and acts as the age verification regulator for online pornography. So there's a whole load of regulatory mechanisms that we use both internally and as well internationally. And it's vital that those networks are maintained and built up and strengthened, because that's the way in which we're going to ensure that data, which of course knows no boundaries, can be in some way sort of regulate and provide the best protection to our citizens, while at the same time allowing the greatest use of innovation by business in order that they can maximize the potential of data and digitization, which in turn should improve everyone's lives. So again, just to finish and briefly, the challenges that enforcement agencies face when seeking to understand innovation is immense. The scale and pace of change is significant and accelerating, and understanding the mechanisms and technologies involved in a process, decision or service operation are complex multiplayer systems which the ICO is now increasingly looking at. Monitoring this requires constant vigilance by regulators, horizon scanning for emerging threats, and privacy issues need to be viewed with a focus on risk and greatest harm. At the same time, many DPAs have limited resources, and they need the technology investigative capacity to understand and analyze tech. We need powers to compel organizations to assist and explain how their algorithms work. We need to monitor and analyze data flows and the need to leverage the capacity of the broader data protection authority community if we're to be successful for our citizens. So again, we need to look to combine and build on the best good work by the Global Privacy Enforcement Network and the ICDPPC with a focus on technology and innovation. And rather than everyone doing their own analyses and research, the community needs to better combine and pool their resources to share their experiences. And just to finish, a few things that the ICO is doing in order to try and push that debate forward on the way to deal with innovation is we've strengthened our technology department. It's now a division in its own right. That's one of a small part of why we've gone from 350 to 800 staff. We now offer apprenticeships to bring on a range of new talent, and we're working with local universities to do that. We have an innovation fund which grants funds in areas of data protection and innovation. We now have an ICO postdoctoral placement looking at the regulation of AI systems and how this may be done effectively to gauge bias. We have a sandbox, a regulatory sandbox, which is a safe space for tech innovators to explore privacy by design in services and products. We, as the regulator, offer insight to the law and gain insight from cutting-edge innovation before they become issues, so we can work with startups and SMEs as to what they're developing. We have an innovation hub with other UK regulators, which leverages broader UK regulatory communities where personal data is being used in innovation in other sectors such as transport, energy, banking, legal services and telecom. And novel and innovative technology is a determining factor in identifying the focus of our high priority investigations and casework. So that bundle of things that we're doing is all designed to try and keep us, as I say, I think keeping one step ahead of technology is difficult for a regulator, but at least trying to not fall too far behind. So that's a brief potted history of data protection, the role of the ICO in collaborating with other data protection authorities, and what we're seeking to do as we look to move forward in the future and deal with AI. Thank you very much for listening.
Number of attributions under ICO and with a political complicator. There are some questions that you may have asked yourself. Rory, wait a little bit. We'll have some questions in the end, and I myself have questions. I will invite Ana Paula to present her point of view. And taking a cue on your comments, I believe that 20 minutes, to start the agency, we had 20 employees. They started with 10, so we are much better than they are. But he talked about lobbyists that work hard for the approval of the law, but when the law was approved, the focus changed. So I start provoking you, asking, where's Brascom? The floor is yours. Thank you, CGI and NIC.br, for inviting us to this seminar, which is becoming more and more important for the Brazilian society. Bruno mentioned the coalition that was built between the business world, the academia, and the civil society to approve GDP, and I hope that we can continue with this coalition in the sense of supporting the implementation of this law as fast as possible. Answering your first question, but indeed, today, there are some concerns which are core for the implementation of LGPD. The first one about the constitution of LPD and the role NPD will have. We strongly advocate the board members of the authority, without which we spent the day discussing the difficulties we had in the implementation of GDPR, and at that time there was a culture of 20 years of experience of data protection and some rates, but the principles were common principles. We have an additional challenge, which is to incorporate in the Brazilian culture the protection of personal data and to make citizens to understand their rights and the meaning of that. And an additional burden is that we discuss sophisticated issues like the automated decision, and we look at big companies, big internet companies that work with this. But LGDP applies not only for these big companies, but for any on the fly. So a small entrepreneur without this expertise to deal with personal data that didn't understand the scope of protection of the law, and we need to create a regulating threshold that applies to this small businessman. So this dialogue and the cooperation between the public and private sector and the civil society in the construction of a standard guideline that really works is fundamental. And I'm highly concerned when we talk about the challenge to develop the culture of data protection. Another layer, which is the judiciary. We have a very basic law that goes into the details of certain rights of the holder, but it has a unique way of working. Some compare the LGPD to the enforcement of CDC. And I believe this comparison is a very shy one, because when CDC starts working, we were talking about part of the society where you have a consumption relationship. LGPD, we are talking about a broader approach. I liked all comments saying that data protection is a discussion of the law of everything, because it permeates all relationships that we have in society. And at this point, an additional challenge to implement LGPD, and where this understanding and cooperation will be extremely important, is in the translation of what was said today, which is the risk-based approach logic presented at the GP that we incorporated in LGPD, and accountability. These are two structuring principles of GDPR that we included in our LGPD, but we do not have such culture. So a huge challenge that all associations and coalitions that can be built is to, will we be able to create a common denominator on how to understand and deploy these both concepts to apply and incorporate the law by the companies. Today, when we talk about the logic of accountability, and I will borrow what Orla said, punishment is not the main activity of NPD, but it's the last resource So the focus is in education. The focus is to understand, to make companies or data controllers to understand the importance of protecting that data, adopt the necessary security procedures, incorporate data protection in their day-to-day activities, and promote educational trainings, be it with the end consumers or internally. But if there is a non-fulfillment of the law, this should be considered so we can exercise a punishment that will take into account the practice adopted by the company and the mitigation of the fine if indeed it was a good faith player. It tried to follow the legislation, and only if it doesn't succeed, the company will be punished. This changed our logic, our legal logic in how to enforce law. So I believe that one of the foremost important challenges and the need for this continuous dialogue is to understand how to translate these principles in terms of the incorporation in the productive sector with an additional difficulties. In the case of sectors who are subject to their own legal system, so banking, telecommunication, we have group of laws, a regulating agency, and this agency will need to create interactions with NPD to build constructors together, but we should respect the legislations of both parties. For those who work in telecommunication industry, we already had this discussion with other agencies in different environments, and we know the difficulties posed by these problems. Each sector comes with their own pains and problems, and it's very difficult to reach consensus. And I'm talking about one single consensus. And NPD will need to do this in different sectors in a coordinated way to guarantee legal securities for companies at different markets. I won't be able to have my data subject to rules that are inconsistent or incompatible with my industry. So this is one of the major challenges this cooperation will have between all parties involved. And this leads me to a different approach. We face a huge challenge today. We cannot translate it to the European reality, which is the discussion of laws at state and city level to discuss data protection. We have a very complex structure. We have great difficulty to deploy LGPD in the federal realm. And if we need to promote this discussion, that I need to respect federal LGPD, state LGPD, and 5,000 cities, this is a huge obstacle that will create a huge legal lack of security. So one of the premises we have today is in the sense to guarantee that the legislations of data protection is a federal one. So it will allow an effective implementation. And a final challenge that we have discussed a lot when we had the discussion of LGPD, it has to do with premises. We held the discussion in Brazil looking the use of personal data as if it were a problem belonging to the private sector. And this is curious because if you discuss the legislations of data protection in different jurisdictions, it was born to protect the citizen by the state. So our approach comes from a different place. And when we talk about technology and data-driven economy, they work based on reliability. They really need to implement all measures to guarantee the responsible use of personal data, not because the law says, but the market requires this. Another point that we need to bear in mind, which is extremely important that NPD understand, is the rationale, the premise of why companies follow that, not because it's mandatory or they will pay a fine. The problem is much bigger, and it's more in the structure of the thing than the sanction and penalties of LGPD. LGPD incorporates this logic when it defines as one of the sanctions the fine. It's not only to pay, but to lose the structuring element of reliability. So we have many challenges ahead of us, and we need to open constantly this dialogue between the academia, the private and public sector, and the civil society. Last comment Rory mentioned, and we don't have the culture for this, and maybe to grow faster in the culture of data protection and learning NPD in relation to challenges has to do with sandbox, to create the culture and the environment to test new business models, to test privacy by design mechanism, this security by default, and that regulator can acquire the experience. Rory mentioned the difficulty of regulators to understand technology innovation. So when we incorporate such logic where there is indeed a protection of companies, it's not that I will show my weak points and tomorrow I will be penalized. No, there they are exercising a joint construction of the public policy. And this is a very important learning that we can have based on the international experience.
Você foi muito sucinta.
You were very brief addressing relevant aspects here. And you mentioned a timely one, companies' concerns, and Brascon represents many companies, 65 actually. 65 companies with a very high revenue, a unicorn or more, he says. CESPRO, which is the IT association, small and medium-sized companies, and their members are dying to adequate the law. If that is a concern of the giant ones, let alone the small and the medium-sized ones. But you touch upon relevant aspects, especially when you talk about a need not to punish everyone and understand the agent's pain. This is the guidance that we hear from the UK. I remember a Mexican professor who showed several films from Mexican authorities where their participation was educational, profitable. Roy, maybe after if you could exemplify and illustrate the ICO performance in education, citizens education, consumer educations for privacy issues, but in a while. Next, Jonas.
Para fazer uma ressalva que, embora ele seja...
Although he's a journalist, he's here today as a researcher representing UNB Communication Lab. You have 10 minutes. Thank you. Hello, good afternoon. I know that it's very unfair to have a cocktail between you and me, but it's nice so we can interact. I also like to thank the CGI. I am here as a researcher, but also as someone who is part of civil society network and participates at the discussion about the general law for data protection.
Tá ótimo, obrigado. No caso, o coletivo Intervozes, e o coletivo Intervozes integra a Coalizão Direitos na Rede, que foi a principal rede de organizações.
This was the first network of organizations that tried to bring the discussion about the importance of guaranteeing the rights of people in this process, which was a rich process where we have some units, but we may advance much more.
Me sinto muito animado de estar nesse espaço, porque acabei de terminar uma tese de doutorado sobre plataformas digitais e acho.
And I guess that today, at today's panels, we don't have to waste more time because they were very didactic, addressing the importance to pay attention to this new moment that they will call as modern monopolies, and some other authors as Stuck, they will call as datapolios, but I prefer to call digital monopolies. But the important is to fix that phenomenon.
Sobre as empresas e as marcas mais valiosas do mundo, de que a gente tem agora entre as.
And what we have now, we have the five most valued companies in the world, which are tech companies. They perform a key role in the sector, but we are not just talking about them. As it was mentioned here before, we are talking about a society collection, datization. This is a terminology that he is saying now. This is transsectional to social activities, and the impact does not take place just in each subject's life. We are then talking about impact over key processes such as political ones, elections, let alone examples as we have been seeing in the UK or in the US or even in Brazil, where our last year's elections had severe denouncements about the use of social media with important impact if that is still an object of investigation. We have to understand that we are talking about agents, and a way to expand to other social activities which will impact people. And when we come to an event like that and we see a concern with adequation, it's normal that companies, they are concerned that's how they will adequate themselves to a new law. But on the other hand, we have to see people that have the rights of those constitutional rights which are in the civil internet framework and restated by LGBT. And when we see these people in face of those companies and spreading data collection process to any business that we have today, there is a very scaring asymmetry. And to work with that scaring asymmetry, we need a toolkit that will be very effective. Although there is a discussion that we should not do about a regulatory approach if that is a decentralized regulation or responsiveness one, as Bruno said, regardless of the diversity of regulatory instruments, they have to be effective and balance asymmetry in the relation among companies, users, people, and not just observe them from an individual standpoint, as Laura and Orla said. And what are our urgent tasks to reach our goals as part of the Brazilian context? First, implement data protection general data. We are in our last year and we have no national authority for data protection. This is extremely worrying. This should be done yesterday to raise authorities, but that's not enough. And then I talk to those who say that authorities, they will not save the world, but if they are not so, they will have a huge task to undertake, and to be able to fulfill this extraordinary undertaking, they have to follow the law and to be effectively autonomous, to be able to guarantee surveillance, its educational role, and all its actions. And despite talking about LGPD implementation, we did not finish that battle for the votes, and they had 3 denials, and they have one related to sanctions, another one related to the end of automated decisions by natural person, and what we would get in terms of disinformation. If we are still debating that, we have to guarantee that this society has proper resources, but that represents a complication. What will that mean in practical terms? I like to be more ambitious. We have to advocate to our authority a large technical body, because here we are talking about not just large companies, but small companies, not only IT sector, but among those sectors with clear ideas. And for that, we need technical bodies, but not just authorities. If that law was a construction of debate around all multi-stakeholders, the committee will have an important role to bring that in the construction of the whole regulation and the role of authorities. Here I have listed some regulations. I counted here 22 of them, but you may calculate yourself. We have to know that there is no doubt that if we have a principle in our law, there is a long list of framework. And after MP 869, which was included in the 603 law, the possibility to make that law more flexible to start-up and business for large business. That may be a breach to characterize that regulation. So that should probably be the most important regulation to be enforced. But we can talk about the right of the legitimacy of interests and revision of automated decisions over checks and balances. In publicity, information about treatment. In the impact report, that is an important tool, but how will that be done? As Kaf said before, how are we going to attest the legitimacy of the interest? What methodology will be used for that? We do need an authority to balance and compromise issues, in addition to some other topics such as sensitive data. In my last minute, let's consider that despite LGPD being part of an urgent being part of an urgent agenda, that's not the only one. Ana Paula has mentioned PAC 17, which mentions data protection inclusion. I fear that if we bind regulation in a federal scope and not be able to identify specificities as we have for some national programs such as facial recognition, which will be a topic for tomorrow. And as Orla and Laura said before, we have to talk about competition. We have to start from LGPD statement. The only mention of LGPD to a specific legislation is data treatment by public safety. And that represents one of the exceptions. The debate about data protection started with a state concern, which is still kept by the society with the surveillance practices, so that specific legislation is key. IoT, what are the boundaries for IoT? How about positive file? And EDEC is conducting a very important task to diagnose blind spots of positive risks. We have another issue, which is privatization. How about the data? How can we guarantee rights once the governmental agencies, they privatize their main database? But there is another demand, which is data treatment. And Laura, she was very precise when she says we can no longer just worry about the collective application, but a quantitative application is key. This information, once we have a CPMI in the Congress, when CGI and the Congress promote seminars, we have to understand what is the specificity of that and how to defeat it. And I close just listing some areas that would require a specific attention. Health 4.0 industry, labor issues.
Por exemplo, quando eu implanto determinado tipo de controle no trabalhador, eu vou regular.
When I implement labor issues, how am I going to regulate it? By data protection or by labor imposition? I'm not talking about a data owner. I'm talking about soil, but doesn't that have a social importance? And to conclude, the challenge of implementing LGPD is just the beginning. The approval for LGPD was just the beginning. Unfortunately, those persisting lobbies, they unfold an important part of LGPD, but we have still an important key framework. We'll have to change the car tire with the car movement. We'll have to have segmented dialogue considering all these agendas, and congratulations to CGI to allow this time for this discussion. Thank you.
Queria agradecer ao Jonas Valente pela sua intervenção.
I would like to thank Professor Valente for his presentation. It was not clear that we heard the government that we would have 20 people available. We were surprised. And CGI said it will help with critical mass. You raised some important questions, and we have many other. I would like to listen how we will work with legacy bases. This is the second silver bullet. The first one is legitimate interest. The other one is this point I just mentioned. You talked about very important points. This bill, we have lost to use of artificial intelligence to create standards, limits, and criteria. CGI is analyzing this topic. We need to promote it, to offer information, and to define the limit of the use of this in a democratic society. So I invite Alexandre Pacheco from Fundação Getúlio Vargas, because from the academia comes the solutions. Good afternoon. I would like to thank CGI and the opportunity to share some ideas here. I will wear two hats here. The first hat is that I'm a professor of the law school here in São Paulo, where I have the opportunities to discuss data protection and other issues related to technological issues. And my other hat is that a coordinator of the Center for Innovation, which plays the strategic roles in the foundation to deform the compliance programs in terms of the project of compliance, But we are trying to create routines to create documents changes and new procedures and to create a cultural change. And when I say we have some open questions here, when we think about a compliance program, some issues involving choices of a sector, which is mine, which is education, higher education, one of the questions was, the Ministry of Education has standards not with technology to protect data, but we have standards about duties relating to information, an important data for students, school records, or tests, registration forms. And those who work in the education field knows one student can be a potential client to other courses. So you have digital marketing initiatives. And one of the questions was how to restructure a project that not only will give sense to words in the legislation, how people from the mathematics school asked, I have a menu of 7 techniques. Which shall I adopt? Well, there are some studies from the European Union and Article 29 that approve 6 techniques without defining any one of them. Even if the law is not this one, my question is, the national authority should define a norm to say which are reasonable standards so you can adopt the solution in a safe way. But when we look the rules for the higher educations, we had many doors to open. CAP, CNPq, the Secretary of Higher Education, and the first thing is that there is no way to ask and what are the connection points. So who did this process were ourselves. We consider each one of them based on a risk analysis, and you'll do this. We missed an open dialogue with a national authority to consult, discuss, and try to define which are safe fields for our choices. But when we try to measure how we can create choices in a complex institution as Fundação Getúlio Vargas and higher education institutions, one of the challenges is to deal what's sophisticated in data protection, which is the design of algorithms. When we think how to operationalize if we remove human beings, the man from the exercise of analyzing the review proposed for the data, I need to have double certification. I need to have a different robot, or I can use the same robot to define again about how to treat those personal data. This is a highly sophisticated problem that involves everybody that works with IT. At the same time that I have these sophisticated decisions to make, I have banal problems like employees who will forget classified documents in the printer because they will get the next day. And I have lots of professionals with access to that physical documents or documents in relation on how to deal with data recorded in our computers and terminals and data that can be transferred to flash disks or many other elements. Before the law, this was not a major concern in terms of routines and procedures. One of the interesting aspects is, if I'm in the education area, this compatibilization is very difficult and requires an approval not only from the academia, but also the Secretary of Higher Education, together with the national authority. This is very difficult to accomplish, because when we define research agencies included in the LGPD, it defines the agencies as non-profit organizations. You have parts of the research done by other companies. So I will have a disadvantage if I do the same activity. If I'm focused on profits and I do research, but with many other institutions, they'll have different scenarios. And you have educational groups doing this operation.
Diretamente relacionados à pesquisa acadêmica.
We have some related to basic education analysis, and they're doing real research with procedures, methodologies, and results published in scientific papers. What called the attention of researchers are the frontiers and boundaries when we need to work in partnership with private companies to develop prototypes. We have some cases of universities doing research projects in the realm of innovation. And I can have cooperation agreements that will produce a prototype, an algorithm, which will have the results divided between the university and the private company that funded that research. Whenever I talk about algorithms that treat data, to a certain extent, I'm saying I have a research activity. I have some points, but if I include this in this realm, I'll have some problems. So these are two major challenges in the education arena, but these challenges require a prompt answer, an answer from those who are trying to implement compatibility programs, and people, groups, entities that by building their compliance programs should do this. This should be mitigated if the national authority was made with a technical group that would understand the first moment of transition is a moment of education and movement. How can I create a transition period that allows me to preserve businesses, that I will be able to see how to maintain competition guarantees from these different size players, and how I can amplify the implementation conditions of care related to data processing and data protection. So I close with this final idea. The data protection law helped us to understand that we never understood ourselves as well. The law opened a door to help us understand who we are and what operations based in data we used to do. And we observed that what we imagine our students, employees, and many other partners knew what was made with the data. We perceived that the level of invisibility was much deeper than we imagined. What we imagined they knew only 5%. And part of what the law is opening to us is we need to intensify this way of knowing what means data protection, while practice routines, cultures, before saying if I change a clause in the contract and creating a pop-up to my digital platform, I solve the problem. We are far from this, but we should start by these one-time changes. Thank you very much.
Muito obrigado, Alexandre.
Thank you, Alexandre. Very opportune, your concerns, and in 2 points you call the attention. Talking with companies in knowing which law, the first thing you should do is to know well your practice, your company, what you do with data. And I may say that 80% of what happens inside the company is unaware. They get surprised when someone says, I have 2 databases. When you try and go deep in the subject, you find more than 10. So we need to know. Another point that connect with Jonas, the role of the council will be extremely important to help in the creation of this critical mass. It should be very naive on our part if we'll have answer for everything. Just to conclude the first round, I salute the presence of José Zilbert, that represents the Special Secretary of Bureaucratization and Digital Area, so he can make his presentation and have all the answers to what we are waiting here. It's a great pleasure to be here. I would like to thank the CGI for the invitation. And I would Rory, desculpe por perder a sua apresentação. Unfortunately, I don't have the answers. It was opportune to have the opportunity to listen to these comments and observations about the topic on how we can develop these public policies and these new regimes. We are talking about 3 dimensions that the executive power observes, and it was under our responsibility to create a decree to structure the agency in the management secretary, and which is a member of our team. A first point that is highly relevant, and maybe this is not the ideal model, especially now, the background or the history of this policy, the lack of knowledge of the civil society, the population, the business community about these issues. I think Alexandre raised an important point. If we have 7 techniques, which is the one that the authority will deem the most suitable, or at least those that should be excluded from the process? These are the answers that we deem urgent, not only to think August 2020. Whenever we talk with companies, organizations, there is a fear that a complete and real process to deploy and implement this legislation is not made overnight. I believe you know this much better than I do. The point is, we need to see a fiscal environment that we have today. What I can say in advance is that the authority will be very lean. What we won't be able to change, especially in a first moment, it's very important that technical qualification criteria be created and be given top priority. If it's a problem the authority has, a potential solution is and I will create a solution now. But if we have Professor Alexandre Pacheco, Professor Renato, Professor Bruno Bion as 3 of the 5 board members, we have half of the solution. This is the point that we should start thinking here, how the civil society and the business community may contribute to the goal. But how now we can promote an impact to the future. The future is Monday. How we together trying to define the best for the public interest. The goal of the government is to look the fiscal difficulties that we face and the importance of this regime. This is a transversal public policy. It will confront expectations in the private and public sectors. It was very fruitful, the comment of Professor Alexandre when he addressed the challenges for the educational environment, on top of what Jonas said, and in relation to public administration. What we see and was announced about privatizations of 2 big public agencies, I may say that both companies, Serpro and Dataprev, are very worried with this subject.
Representando seja o presidente Caio Paes de Andrade do Serpro, seja a
Being Cristiana from Data
equipes, não sei se o Conrado Rosa está por aí, está ali, justamente eu acho que isso reforça.
That reinforces. He was mentioning some people that are present. That reinforce our regular meetings that we have to face challenges. There is no authority. That is a fact. Until my position, my job position, I was not told who directors are. But the fact is, in face of such a scenario, what can we build up to consider a model or a regimen which is effective and efficient for data protection in Brazil. Several international benchmarks studies are being conducted. We have a constant contact to authorities for data protection, not only for the European Union, but also some other examples from other places, as we are assessing campaigns that were effective. That is elaborated by authorities that had effective reach to inform the population. Listen, these are your rights. In a very ludic way, even to kids. This is one of the issues for best international practices, where we have a study with 45 priorities. Just by the number of topics, the word priority no longer makes sense. But that is a transversal public policy which will face several challenges. If we just think about the financial system, at what extent the data protection authorities will dialogue to central bank, to economy, to the Ministry of Economy, not at today's market, but from now on, new business model that will raise implemented 5G in Brazil. How the business community will make those changes effective. So we have different dimensions. First, normatization. It's crucial that authorities will manage throughout public hearings even better these topics of priority as quick as possible. bring that to the public debate. A second fundamental front is institutional dialogue. We celebrate a technical collaboration agreement with the European Union delegation to forecast debates like that. So there will be specific technical meetings with Dutch authorities about open bank to prepare this field to the institution of authority. So institutional dialogue as well as educational dimension. And here I talk about citizens' information, which is advocacy, he says in English. The authority will have these three clear dimensions and a responsibility in terms of urgency. August 2020 is knocking on your door. And what we learn in the government is that things are not as fast as they could be. Most of you would imagine that by middle of September, we would have 5 nominated directors and the members of the National Committee. And how can we, from now on, take the next step to construct a regimen which will not be disbelieved? If there is no technical qualification of directors and members of the National Committee, it will be very difficult that by 2021 this regimen just vanished or was not effective. Why? Due to some reasons that we'll try to explain later on during the legislative history. But it's high time. The next 4 or 5 weeks will be fundamental for those who dedicate their time to this topic. So do as much as you can to have a substantive volume of data protection and learn from the best regional international best practices, because if we look at our neighbors, Argentina, Uruguay, and Mexico, they are doing wonderful stuff in this field. So I think we can, learn from best international practices, including regional ones. So this is my home take message, and I'm at your disposal. Once again, thank you for your invitation and attention. Thank you. Thank you, José. It's always very nice hearing you. We are glad once the government shows this broad vision about the importance and the multiplicity from different standpoints which should be considered as part of the agency creation. You had just mentioned the 3 places. Your CV probably is in the civil house, so you can be nominated. That would be very profitable. Why not? Jokes apart, before we open to the public. Five places, 5 vacancies. Well, 2 or 3 would be reasonable. Before we open to the public, I would like to invite you, Rory, to make a comment which will make sense, of course, based on reasons and concerns here addressed by each one of the speakers, from your perspective, of course. But I will start with my question, which is, what is your understanding? What was, in fact, the ICO educational role as part of this process regarding data protection law, or GDPR?
Thank you, and thank you to everyone else who's very interesting. I've enjoyed listening to you all. Education, as in education of the public, So I think that the regulator, this would have happened before my time, I'm hedging my bets here, would probably say we regulate processors and controllers, and therefore we give them information rather than necessarily giving huge amounts of information to the data subjects. That said, we do have a very high web presence, and we sort of ensure that we're sort of reaching out to other sectors, but primarily and historically, although I think this is, if it's not changing now, it's likely to change, the information has been primarily for businesses and for public sector organisations. One of the issues that we've had, and I was discussing with some people yesterday, is that, and it's something to be mindful of when setting up your own data protection authority, is that it's very easy to become what we in the UK called a DPO for hire. So you're constantly, or rather not me, but we found, the ICO found that members of its staff were constantly being required to give advice to businesses who, for one reason or another, certainly pre-GDPR, weren't required to or couldn't afford to have a data protection officer or legal advice, and so they'd phone the ICO and say, "Oh, I've read your guidance. I think it means this. What do you think?" And that creates a whole range of problems. When you've got relatively junior members of staff who might be dealing with quite complex data protection, legal issues, and there's liability questions, et cetera, et cetera. So one of the things that the part of our growth is that also we've restructured, and it's to try and move away from that DPO for hire profile, I suppose, so that we're providing information and guidance. And if anyone cares to look at the ICO website at the moment, probably the first thing you'll see is something about Brexit, because we've just revised all our no-deal guidance about what happens to what businesses should do if there is a no-deal Brexit. But I think increasingly we are beginning to look at what more we can do in terms of informing data subjects of what their rights are, and in a sense, therefore also their responsibilities in terms of keeping themselves private, etc. And so part of that is, part of it isn't really, but there's the age-appropriate design code, which is coming out, which is all about not regulating the internet, but identifying that there are issues with the internet in terms of the way that children access it and some of the material that's available, and how might that be something that a regulator could usefully look at without straying over the bound into the realms of censorship, etc. So there's lots of tricky issues, but I agree. I don't think, and as I say, I've not been at the ICO very long, I will hazard a guess to say I don't think we've done huge amounts of public outreach, although we're a well-known organisation, we're well-known in terms of our enforcement and investigatory powers. I think it's something that we're going to be doing more of in the future. I think, I mean, the main takeaway from I think what everyone said is the we've heard lots and lots of things today about the different powers that a regulator can have, and there's the issue of a data subject's control and whether that's really a truly helpful model. And obviously, we want to put data subjects and consumers in charge of their own data, but is that really sufficient? And but also, how can a regulator which maybe lacks resources, even if you're as well resourced as the ICO, which is certainly the largest in Europe, if not the world, struggles to keep up with the advances and the technological advances. So there's a lot about collaboration and communication and working together with internationally and also internally with other regulators. There's the public debate. There's trying to shift a certain, and this is a really difficult thing, the responsibility onto big data harvesters, if you like, even if they're harvesting our data with our consent, to start behaving more nobly, if you like. I mean, it might be a big ask, or honourably, but there's a whole bunch of things there, and also whether I don't know if Dennis is here, but certainly Professor Dennis Hirsch, who's speaking tomorrow. I was lucky enough to hear him speaking yesterday, and certainly, you know, what is the future for this sort of regulation? And it's probably regulators and consumers accepting they're never ever going to really be in charge of their own data, because the barriers to entry, the asymmetry of information is so great that maybe there needs to be something where there is some, you know, supranational body that can identify whether standards are being complied with. So sort of you're regulating the regulators, if you like. And I think that's something that we need to consider. We're not there yet, but I think that's probably where we're going.
Question of culture. When we see the need for a Republican attitude, he seeks a noble solution. But let's open to the audience. Who would like to ask our panelists? Don't be shy, please.
Tem alguma pergunta? Já lembrei de...
Flavia, I remember two fantastic names on top of you. Good evening, Renato Leite, Pepsi Brazil. The question has to do with what Rory said, all of you said. It's a regulatory sandbox. It has to do what's being done in different countries, like in the UK. Can I... everybody in the room knows what's a regulatory sandbox? I will tell. My father was a doctor, and my mother said, you were teaching a class, it was so basic. And my father answered, I know my public. So I think you better shed more light for those that by chance is not used with the sandbox terminology. But so many people know what sandbox, the regulatory sandbox is to make some rules flexible, some rules adopted, depending on the type of regulation, to be an incentive to certain changes and innovations or the economic or technological development. We have some rules which are specific for GDPR of what can be changed. We are being flexibilized, and we observe in a controlled environment startups and business models that we can innovate and influence other business models. This is my coffee and milk. Well, taking a cue on what Pacheco said and Rory discussed, we don't have data protection. So the authority will play a big role in educating, training, and giving guidance. And I would like to ask Zibaj the following. In the structure that is being designed, we don't know which is the structure, is it feasible to have a specific flexibilizations for disruptive business, something that can be included in the concept of a regulatory sandbox? Yes, it's possible. The structure of the authority was formulated with 3 general coordinations, and the first that will be launched as soon as the decree is published is the one dedicated to standardization. It seems to me there will have plenty of space for this kind of initiatives. But even though we have the best article included in a decree, it's an empty voice if people are not able to understand the concept of sandbox, for instance. So we will go back to the first point. We have space for this. Not only for this, but at least the draft of the decree that we are discussing, the draft includes a series of precedents that in the Brazilian public administration I would consider a step ahead, be it to analyze the regulating impact, public consultation. All these measures are part of a legal framework that will allow, there is a big concern, a healthy concern about the National Board for Data Protections. We'll have 5 seats, but we don't know how will be the structure of this board. We won't have seats for all. There is a specific number for each representative. So through public consultation, and this being declared in the drafts, it's a great opportunities for all institutions, either the business community, the civil society, or you citizen that deem that topic important, to include your point of view or comment in it. This goal, or this, we have this concern, and it's possible, but we should say that the letter of the law, without the right persons, won't solve any problem. Flavia, if you want to tell the experience of the consulting board, no, I would like to take this opportunity to ask, given the condition that we won't have by August 2020, the national authority already implemented to be able to implement in a broad and satisfactory way all the aspects of the law. How do you see, once you have acknowledged that there is, or there should have a coordination with other agencies that also works with data protection, like Jonas said, CADE, Senacom, and many others, which role, when the law is enforced, what is the role these agencies will have to a certain extent to guarantee that we can implement the law, especially for you, Jonas, and Paula, and Alexandre. I'm extremely concerned. I understand our urgency, but I'm concerned when we look at the situation today that the agencies that would work with data protection, but this is not their call. They shouldn't start to work about the constructions of the understanding of data protections. How CADE see data protection has an approach about competition and not data protection. So I'm concerned with this path, but we shouldn't stop. we mentioned that the work we were able to do with different sectors, why shouldn't we continue with this work with the support of CGI and maintain the open discussion on how we are going to face that we have a list of 45 priorities. Jonas presented a list of sectors. Can we start to discuss this as a society and confront challenges, seek international experiences, and map how this connects with what we have internally? Because it seems to me this is much more positive in terms of input for the authority than start disseminating competencies of the inform of data. I hope by August 2020 we have the authority.
É isso, né? O que o José colocou é...
But that's it. It's not enough to have the authority. We need to have the authority, and we need to have details of all the norms and guidelines. I listed 20, but each one may have its own items. When we face concrete situations, and the situations popped up along the day, and including extra LGBT. We have a bill, anti-crime bill, that deals with the genetic banks of private people. How we are going to discuss this? So we have aspects on LGBT that can have a specific regulation that won't solve what LGBT says. So we have PAC 17, but if the authority do not start to operate right now, the space will be occupied. We need to do the reverse work. We need to have the authority as soon as possible. We need to shed lights on all the blind spots, and we should guarantee coordination. No matter how these agencies touch, what's becoming more and more clear, and Professor Orler was very clear, CAGE cannot be an authority that will get involved only with technology companies. It can observe data drive or a way to protect data in any merger, as well as Senacom has a checking process underway. So Flavia's question is very opportune, but I hope that we do not need to go through this and that we can move forward as a society, because it will involve society in the national board in a coordination process that reduces overlapping of work, reduces. So the zone that we let it with me, we can't have an overlapping of work. And as was mentioned here, at certain moments, with the same facts and episodes being treated by different regulatory agencies. So the government has the ball, and we want that the article that talks about the law being constructed with dialogue with agents, it should be implemented at such an important moment.
Por favor, Alexandre.
Bom, eu tenho dois comentários rápidos, deles direto.
I have two brief comments. First, we have a challenge directly related to technicity of members of a national authority, and I hope that we can have at least two females. And another very important detail for authority purpose is the least technique she is, the higher will be competition, being from consumers' rights entities or any other entities which have in their norms information, and they will not see as a technical branch the national approach to conduct their work. With that, you have to create technical collaboration agreements and inter-exchange of members of the House, and if a national authority does not have that body that starts with directors, it goes through different cabinets, and they will find echo of recommendations in the national committee. If there is no framework where central bank, education, ministry, economy, and others would see them as being a technical branch, if they do not give me as part of that specific competence necessary contributions, I will keep doing what I used to do with that theme, which I'm not an expert, but somehow I can do something which is a little bit better than what is supposed to be average. Another important detail is that we've seen in the past a time where these constructions, they were not spontaneous, and they are part of a negotiation process which will deal with acknowledgement of what is my competence. Central Bank and CAD, they had reached a common denominator of fusions and acquisitions. What is each one's competence? National authority will have to build space like that, and the best personal card they can give is I may qualify service delivery to the population, the exercise of your competences. Once you familiarize you to different terms, I have instruments that I may use jointly, but more than that, how can I organize what is mine, what's yours?
E nesse sentido, a gente está num dilema fundamental que é, se as indicações...
And we have a dilemma. If indications they do not have a technical component of their names, after all, we'll have an institutional immediate dispute that will take to a second plan national authority.
Sobre a sua pergunta, Renato, uma das coisas que eu acho que é um passo até atrás do...
And what is a step behind the sandbox is to identify who should be qualified as a startup, as a differential for who can undergo a request to be framed in the regulatory sandbox. A startup should be the size of the company, revenue, as the taxes legislations, how they deal with small companies and micro companies. In Brazil, unfortunately, we have the following. You create a strategy to be always a small company, to be always qualified as so. After all, we do not want companies that are not companies of high potential for growth that can, at a time, when they see that being a startup represents an advantage from participating at a regulatory sandbox, and to fit like that. For that, we'll have to create a new startup concept which is not based on revenue and technological characteristics associated to personal data. And more than that, they will have to justify why flexibility is given to it. What sort of benefit are you adding to the society when temporarily I can define an advantage to you? So you can learn, you can make your products or services available in the market in a safe way and from a data protection perspective. If we do not have a concept of a startup, of what would be a startup's status and benefits taken from it, we are not able to implement a regulatory sandbox to this group, let alone others.
Eu vou fazer uma proposta de encaminhamento. Ah, você queria falar, Zé? Desculpa. Não. Essa pergunta ainda? Tá bom. Na sequência, eu vou ouvir as 3 perguntas remanescentes que já manifestaram, aí eu passo para todo mundo responder e complementar uma fala final.
Só para direcionar, vou dar 2 exemplos que passaram lá pela...
Ana, there are 2 examples that they have been to a special decree, a federal decree, which deals with data sharing in public administration in the executive part.
E é uma das missões nossas, como
And as a special secretary, one of our goals,
o documento nacional digital, qualquer que você queira chamá-lo, a gente já endereçou várias medidas para isso, por exemplo, usar uma base única que seria o CPF, ter esse documento.
a unique platform for CPF IDs where we could offer several services to the population.
O compartilhamento de dados ele é fundamental. E para nós foi uma dificuldade redigir esse.
And it was so difficult.
Que a gente falava, olha, primeiro que ele, na primeira minuta não tinha nenhuma.
First of all, we did not have any mention to LGDP. Fine, LGPD, but all concerns, principles were stated, principle of reasoning. But the fact is, and I share what the private sector say when they say, well, we do not know what the next step will be. We do not know what is the best technique. And we try to pass that decree. And now what? How to take that further step? Can we detail that a bit more or not? That is a federal decree after all. And another one within the management secretary, just to echo Renato's and Alex's concerns about companies. Government wants to incentivize technological investments. They want to invest and to propagate new business models. Fine. And we even want to hire you. Okay. But what is the rule? And one of the reflections is, one ruler is enough, or should we need a more flexible and dynamic model? And this was one of the issues that we placed in our list to oblige authorities to revise their inventory. I mean, you issued that rule in 2025. Does that still make sense? In Brazil, we have a culture, Roy, where each entity, each agency have their legislations. Pages like a Bible. Pages and pages with the norms, instructions dating from the 60s and 70s. Believe me, that's why we also want to observe that such a dynamism that this authority should have is key. Until December last year, I used to teach at the University of Melbourne in Australia, and that was one of the points once interacting to the government. I used to teach in the law school there, and there was that permanent and constant worry that the world is changing. It changes every single day, and this is not unique to Brazilian government, but to all governments, that they have a specific step. And how can you, in this coordination, take that specific step into something more dynamic, a more flexible space, allowing a more agile interaction? This is the challenge that I see to governors, not only in Brazil, but at the 3 federal levels, which is another complexity that has been addressed here before by many, but this represents a challenge to all public administrations. Those are 3 people who asked the questions. Can you read it, please? It's a question from William. He wants to know if National Agency for Data Protection, if that is related to the presidency, will that be for the good or for the bad? I have a question to Rory about Let me put that into a context, first of all, okay? We have elections in Brazil every 2 years. And your agency is conducting an investigation for over 2 years about the use of data analytics in political campaigns. And the ICO term is even broader than this agency because it allows search and and that was done in the headquarters of analytics in London. And if you could share a little bit your experience about this topic, and if you could clarify at what extent the ICO term is good true, and at what extent the agency may collaborate to other players in an effort to guarantee integrity of electoral processes. I will give you the floor in a little while, Royal. Just a second. I also have a question to you, Royal. Due to your experience in the ICO, with your experience in the ICO and some other data protection authorities in the UE, what would be the main element that authorities should have to be considered a real authority to be able to take Brazil to be considered a country with a proper level for a free data flow between European Union and Brazil? I will start with you, Rory. Thank you.
Okay, thanks very much. Well, that's put me on the spot. Okay, so I can talk in a minute. I just need to get my notes because about Operation Cederberg, which I think is what you're referring to, which is the investigation into Facebook and Cambridge Analytica and the alleged, I'm not sure if it is alleged anymore, but anyway, let's say alleged mishandling of data or manipulation of data for political ends during the EU referendum. And I have some facts and figures about that. I mean, it was a big operation. In terms of, so my experience of the European Commission, when they look at a country's suitability for adequacy, there's all sorts of things that they look at. Of course, the first thing that they're going to look at is what's the data protection law in that country like? How closely does it meet the European standard, and how sure can we be that it's going to, that transfers to that country of European citizens' data are going to be safeguarded in, or have the same level of safeguards attached to them as it would be if it was being processed within the Union. That's the overriding principle of adequacy. And they then have, there's probably three key things that they look at in overarching all of that. And I'll do them in reverse order. How does the country in question process national security data? 2, how does the country in question handle onward transfers of data to other third countries? So would it be likely, for example, that if data were transferred to, European citizens' data were transferred to, let's say, Brazil, how likely would it be that Brazil would be able to provide the same level of safeguard in a transfer out of Brazil to another country as would be provided by the EU? So it's basically what's known as the sieve mechanism, right? Is the country that the data is being transferred in then going to be a sieve for it to go to anywhere else which isn't then safe? And the first and most fundamental is, does it have an independent data protection authority? And when it talks about independence, it means free of political interference, free of, and that goes to funding models. So, you know, well, I don't need to explain that, I don't think, but, you know, could the government arbitrarily decide they don't like the way that the Data Protection Authority is behaving and therefore cut its funding? If that's the case, it's not independent. Could political pressure be put on the Data Protection Authority to behave in a certain way, either through appointments or sanctions, etc., etc. So in the UK, for example, the Data Protection Commissioner is appointed nominally by the Queen. Effectively, it's by Parliament, but because of our constitution, which is going through all sorts of issues at the moment, that power resides in the Queen, although it's vested in Parliament. The point being that the Commissioner is appointed by a free and open, transparent process. There is a recommendation made by a government minister, but in practice it's very unlikely that the government minister would override the independent panel, and that recommendation then goes to the Queen, who makes the appointment, so it's Parliament, and the only way that the Commissioner can be removed is by an act in both Houses of Parliament. So the current Commissioner, couldn't be removed if, for example, Boris Johnson decided he didn't like her. It would have to be an act in both Houses of Parliament. So it's a critical thing of independence. So, I mean, that's a sort of longish way round of saying that the way that the Commission will look at an adequacy agreement with Brazil would be, the starting point would be, what does the LGPD look like? How closely do we think it matches our standards and safeguards? Does it provide provision for the things that I've just mentioned? But overriding all of that, it will want assurances, objective assurances, that the Data Protection Authority is independent. And it will probably also, it's independent and effective, so there will probably be issues there about resourcing, like can it cope with the amount of cases that it's going to get? Can it provide proper redress to the citizens I mean, primarily they'll be concerned with, can it provide proper redress if there is a data breach of European citizens' data in Brazil? But a sort of a priori question they'll ask is it able to provide proper rights to data subjects who reside in Brazil? i.e., is it resourced well enough? So, I mean, that's quite a big issue for them. Can I pass on to someone else and I'll get my notes about Cederberg?
Maravilha. De maneira muito breve.
So
E pensando
briefly, and some additional reflections about independence, its structure, the creation of a national authority where we create an option once that internal regimen, within 2 years we might consider the possibility to take that into a special agency. And the main problem is the sign that we give with the idea that within 2 years there will be a possibility of that conversion to be a certainty or budget economy. And I let it very clear. We live a time of fiscal crisis. In the logics of strategic central topics to a country, we should not think that a national constitution with a minimal infrastructure to its execution is that technically enough. If it were, we wouldn't need to think, in addition to have 5 directors, and we would not need to give any additional sign of autonomy once that we are taking that tube quite late. Thank God we are riding it, although we are late. We have countries, Latin American countries, which have a tradition in data protection that, after all, they are ahead of us. So in addition to the fact that Roy listed the constitutive elements, what in Europe would be understood as independence, my comments are, what sort of signs are we giving? We are giving a sign to postpone an important autonomy decision about the structure of the authority, and an important sign to which technical profile will help directors within their competences to execute their tasks. It's a set of signs that make us understand that we are a little bit far away from that idea of independence that we would like to present as international sign. However, we are in an important starting point. We have infrastructure, and we want to become more appropriated to European parameters, not only for international transfer, but for inter-exchange with organizations. And if there is anything else which is important to take from this session, there is something very important, which is cultural barrier. And by cultural barrier, first of all, what I mean, and this seminar is part of this effort, that is sensitization, sensibilization, and to get familiarized to those concerns, part of the legal document. And we can tell by the number of attendees here today. We had full house. There is a concern, courses are present, professionals as well. But more than that, we have to think that now, once you think about data protection, in reframe routines and platforms. And this is a huge challenge because we lawyers are not trained to consider systems interface. We are not skilled to think about users' experiences and things like that. But maybe from now on, it's high time we start worrying about it as part of data protection. That's it. Thank you so much.
I can say a bit more. Thanks. So just back to the question about enforcement. Sorry, I do have to refer to notes here because I don't work on the investigations section. So it's quite complicated. So if we're talking about the Cambridge Analytica and Facebook case, which was the big one in the news, which resulted in the liquidation of Cambridge Analytica, it was a huge investigation. Just to give you some sort of indication, there were 172 organizations identified as being involved, 30 of which formed the main focus of the investigation, 71 witnesses of interest, i.e. were interviewed, 285 individuals who related to the investigation, 22 documents seized, 85 pieces of equipment, including servers, 700 terabytes of data, which is 52.5 billion pages of data. It took 40 ICO investigators, and we issued 31 information notices. It involved 58 overseas agencies, and as I mentioned earlier, 50 nations were involved. We executed 3 warrants, issued 2 monetary penalties and enforcement notices, and there was a criminal prosecution. I mean, that's huge, and I think it's possibly one of the biggest that's ever taken place. We recently have issued a large breach notice against British Airways, which I mean is out waiting for their comments, and we'll then go into the one-stop shop mechanism, but that's £185 million. That's a different sort of thing. So I think your question was about how you can respond to sort of allegations of electoral impropriety with data. It's like all of these things. I fear that the, if you like, the bad guys are always one step ahead because the technology is sort of, it's the same as with cybercrime and all these sorts of things. That, you know, people exploit the technology possibly for ill before it's realized that it needs to be exploited for good. And so that's one of the things that I'm talking about, about our work in trying to get, you know, at least keep pace with the game, with the, you know, as we talked about the sandbox and the grants and apprenticeships and all that sort of work. We've currently got, there was a recent article about the way in which data may or may not have been harvested by the current government in the lead up to to some of the, in the run up to the next election. So there's talk about all of the data that so at the moment, if you go onto gov.uk, you go to a different place. So you might go to get your driving license, or you might go to get a European health insurance card, or you might go to pay your taxes. And that's all sort of held in different ways. Now, there's a recent allegation that the Prime Minister's office insisted that all that data be scraped into one place in 6 weeks. 6 weeks it may or may not have escaped. Well, you won't have realised, but for those of us who live in the UK, 6 weeks is around about the time that we might be leaving the EU and having a general election. So why is there a rush for number 10 to centralise all of this data? And the answer that they give is, well, it's because we want to make sure that we can provide a better user experience from the beginning of the process to the end of the process, all perfectly legitimate. Like the aims that the government states, because and they may well be perfectly truthful aims, and the ICO is not involved in an investigation or anything at the moment, but it's just to give an illustration of the fact that there's this happening, and of course, immediately people start to think, well, why does it need to happen now, and why does it need to happen so quickly, and what's the ICO going to do? Answer, what is the ICO's locus here? Because it's an allegation in a newspaper report about something the government may or may not be doing. We don't know if anything is happening yet, so there's that. And then you have the whole other bit, which isn't within the ICO's regulatory powers, and I suspect won't be in the Brazilian authorities' regulatory powers, which is just, you know, sort of the rise of bot farms and general misinformation. So there's been a massive spike, for example, just after Boris Johnson lost his vote to prevent him suspending Parliament. Within the next week, there was a huge spike in the thousands of exactly the same Twitter message appearing saying, Boris for PM, I back him 100%, you know, and there were thousands of them just all springing up, you know, presumably bot farms, who knows where they were set up, not within the ICO's remit. And anyway, I'm not really answering your question. I'm just saying it's a big issue and it requires a lot of sort of, again, I come back to my theme, I suppose, of regulatory cooperation and trying to work out what the best ways are of dealing with this sort of ever sort of expanding issue, which is that, you know, data and data innovation is clearly, if used in the right way, for the benefit of everyone. But there's increasing evidence that certainly in the developed world, I think that it's being increasingly used not for good and creating not more problems that it solves, but definitely creating a whole raft of new problems we're not used to dealing with. And I think regulators are struggling to keep up with that.
Now I'd like to ask you for your closing remarks because we are running out of time. We have just little time left. I'd like to go back to Alex's comments. We have a set of negative signs about the independence of NPD, and there is a consensus that we needed an independent agency due to a number of political, financial issues. That was not possible, unfortunately. And we have today authorities within the Federal Public Administration. I do not see that as a lost case, despite negative signs. Does law guarantee technical independence and decision autonomy to this entity? Even along to what Zé Antonio said, we are facing a time, 4 or 5 definite weeks for what that NPD will be. And once we are able to guarantee technicity of members of the board and director plan, and once that technicity is guaranteed, not necessarily we are facing a situation of unmet adequation, or if we are not able to have a transitional model in 2 years, everybody is gone. Everything is gone. Sorry. You mentioned Uruguay as being a regional reference in maturity in legislation and culture for data protection. The Uruguayan legislation has a similar writing to LGPD. There is no financial autonomy by the entity, but there is a technical independence. The challenge now is to guarantee that with our NPD, that we are really able to take an independent action, checking personal data by the private sector, by these independence optics, by the public sector, to show that indeed that makes the law approved in its broadness and scope.
O timing do evento.
So this event is very timely, as we had to mobilize and to make much noise to guarantee that this independence will not be dead, but being effective.
Para terminar, eu me somo, acho que já tinha colocado isso na primeira fala e venho reafirmar.
Well, I re-emphasize that this is not just a matter of a sign, but how to have a law enforcement. How are we going to guarantee it if authorities, they cannot construct legitimacy in practical terms? And that can be done by its condition to be independent and to be able to execute its requirements. And even we may have it, we are facing a transition. We have to have an authority creation as quick as possible. But that may be done valuing an independent character of the authority. But that's not just the creation of authority. That structure is the technical body, build up, solutions. I don't know if we have a qualified workforce at Anatel. It's key that there is a permanent structure, but that we can do whatever is possible to be done now. And finally, reinforce data protection national committee. This is a sign that the government can give. Once they do that in a dialogue with stakeholders, and are part of the debate of data protection, this is the idea of independence. And I hope that is reproduced in the discussion of regulations. And with that, we'll be able to see the law principles and to gain standardization and normatization, to be able to answer and for people to be able to know how their rights can be guaranteed in practical terms. Thank you once again for the invitation. I am at your disposal, and I value all organizations which participate at this process to keep on debating within the committee, so the committee can be a place to subsidize these two agencies, which will be created as soon as possible. That is what we hope. Thanks for the invitation. Several aspects have been raised here, and there is a keyword, a buzzword, that we have to understand the urgency of this word, which is infrastructure or framework, this regimen for data protection. And if we want to have a country that has a strength in digital economy, if we want, And here I'm talking as a member of the federal government. If we want to have a digital public administration, if we want to have that process of digital transformation, which is one of the goals to offer 1,000 digital services to citizens, as we did with the international vaccination cards, is key that such an infrastructure for data protection will be really robust, solid. After the work of authorities, which as part of an institutional process will be necessary in that development. So it makes sense consider attrition factors. CAD, when that became an autarky back in the 90s, it went through that process. It's natural that institutions, once they are created, that they interact to others, and that will lead to attrition, tension, stress, and we hope that they will be removed as quick as possible. In the case mentioned by Alexander, that took longer. Central bank resolution was not an easy and short-term resolution, but this is part of an institutional process that the Brazilian state goes through with some, as well as some other governments. But the key aspect is to see that regime as a basic foundation to this new economy, which is not in the future, but is here now. It's knocking on our door. If we lag behind, we will pay a price that will interfere the progress of the country, innovation, and economic development will be interfered. Therefore, it's important that all players and stakeholders participating at this endeavor will reinforce the priority and urgency of this theme, where the executive power and legislative power would play their role. Not just the vote, the presidential check and balances were done. The Congress still has to debate about that. So it's fundamental that we give more priority to this topic. And one final comment. Within those 45 topics, we have the one mentioning political representation, how data and electoral process interacts. And I'm not only at your disposal, but let me make a public, let me be provocative publicly. Anyone who'd like to collaborate and interact, feel free, please. We have to collaborate in that effort to have indeed a rather digital country with more citizens' access by smartphones, and where we may offer to future generations a more digital country with a high economic development. Thank you once again. Thank you all. Thank you to those who stayed till very late. I believe that this debate was very productive. Thank you so much. On behalf of CGI, you are all invited to come back tomorrow at 9:30. Thank you. Enjoy the rest of your evening.